Hello and good morning, good afternoon, good evening, wherever in the world you are. Today is March 3rd, 2022, and welcome to We'll Work for Food, the New Possibilities Hour. Today, our special guest is someone I'm thrilled to have join us, Lisa Angelo. She is a former partner of mine, full disclosure. She's a partner at Murchison and Cumming in she's actually now in the Irvine office, and she handles professional liability cases, general liability, products, premises. She does law and motion and retail practice groups, a wide variety, but her primary focus is professional liability defense. So she's on the defense side of things, and she tries lots of cases. She gets defense verdicts. She gets cases settled, possibly because she's known to not be afraid to try a case. And anyway, she really, I think, is an epitome of an epitome of an excellent lawyer. She is a member of the California Bar, the Washington, D.C. Bar, the U.S. Supreme Court Bar, and the tax bar, right? I believe, yes, and practiced law when she first started out in Washington, D.C. So we're very pleased to have Lisa join us today. Her presentation will be a dual type, one about practicing litigation and all, which then ties into settlements and mediations in the post-COVID world, as well as talking about professional liability and litigation involving insurance and real estate agents and brokers. Let's see, your food bank is the Long Beach Regional Food Bank. And so that's fantastic. And speaking of food banks, Natalie, what's our number today?
Hi, Jean. Thanks very much. Welcome very much to the program, Lisa, Angelo. We're glad to have you. Glad to have everybody who joins us each week for a We'll Work for Food program. These are extremely valuable presentations, and we hope that you find them so valuable that you'll be inclined to make a donation to a food bank near and dear to you. And this week is a big week. This week, we get to announce that we have finally topped the $250,000 in funds raised for food banks around the world. We now have received confirmation of donations that is $250,112. Thank you all so much for your continued support over these last 103 episodes, and especially for your incredible donations to food banks.
Amazing. And thank you, Natalie, for dreaming this up and getting it going and carrying us through this every single week. It was something to look forward to during the pandemic and the lockdowns. So nice to be able to get together with this community, whoever might have signed on that week. So I think we all definitely had a special benefit coming from it, as well as the giving part of it. So thank you for that. All right, well, let's get to it, Lisa. Why don't I just turn the floor over to you and tell us about your food bank, and then take it from there. Thank you.
Absolutely. Well, thank you everyone for having me. Thank you, Jean, for the invitation. I am a partner at Murchison and Cumming, and that is where I met Jean, who was the managing partner back in 2008, who was an inspiration and a mentor. And it is a privilege to be here today. So thank you. I love this organization. I was reading up on it even more as I was preparing for my program today. And I have chosen the Long Beach Rescue Mission. I'm going to just share my screen here. And this is a test to see if I can do this later on as part of the program as well. And I can see it's already not working. I will stop that for now, but I believe that let's try this one more time. Okay, here we go. You see me right here? That's Mexico sailing, parasailing. But More importantly, let's talk about my rescue mission. It's the Long Beach Rescue Mission. This is their website and the contact address for them. And I learned about the rescue mission when I moved to Long Beach from Washington, D.C. in 2008. And I was in my apartment and I received an envelope in the mail asking for just $2 to help feed somebody for Thanksgiving. And I thought, all it is $2. So from there, of course, we donated more. And it's no better, greater feeling, I think, than to know that you're helping somebody eat, particularly on Thanksgiving. So I'm happy to spend today and to have some of these monies at some point go towards the rescue mission. I do specialize in professional liability, in particular representing attorneys, insurance brokers, real estate agents, directors and officers, some employment professionals as well, masseuses as of late. But I'm also a trial attorney, and I have tried cases on both coasts in federal and state courts. I even had a COVID trial in October of 2020 in masks and before vaccines, which is hard to imagine these days that I did that, but here I am to talk about it, survived. And with a lot of trials, as you may or may not know, a lot of professional liability cases don't really make it to trial. We tend to settle our cases. For one, there's usually consent clauses, and there's usually more high exposure. There's a number of reasons why professional liability cases tend to settle. You're all mediators and arbitrators here, probably know. But retail and general liability cases usually will slip and falls make it to trial. And so I have my fair share of those cases. And in fact, I also represent a lot of nonprofit organizations, including shelters and missions in downtown Los Angeles. So pretty vast spread here. But what are we going to talk about today? I'm going to share my screen one more time. And let's see here. Some of you who registered for this program may have seen this exhibit. I'm calling this Exhibit B. Today we're going to talk about litigating in a post-COVID world. And then others of you may have logged on to LinkedIn at some point and seen that today I'm going to be talking about cases with insurance brokers and their exposures and the wildfires, et cetera. And both are true. And you got to see two pictures of me in two different areas, and perhaps maybe that's how we made it to the 250 and the donations, I'd like to think, but we don't know. In any event, I am here today to talk about insurance brokers, and how it all happened was I was meeting actually with Jean for lunch several months ago in January of this year, back when COVID was still very much with us, and everybody was still wearing masks, and it was kind of hard to imagine that just a couple months later we'd be talking about taking our masks off. And I was telling Jean about a case that I had just settled that involved a homeowner and an insurance broker that I defended, an insurance broker agency in Southern California. And this case involved a homeowner whose house had burnt down in the Woolsey fire, which was a very large fire that happened throughout Southern California and in Ventura County back in 2018. And I told Jean about how difficult it was to settle that case. And of course, she's like, why was it so difficult? You didn't have me, perhaps I could have helped. And I said, no, it was difficult because of two things. One, the case involved the California Fair Plan, which is a particular type of insurance that California offers for homeowners whose carriers, previous homeowner carriers may have not renewed their policy or dropped them because their home is now determined to be in a wildfire zone. And so they need to get special insurance for that. And then also, it was difficult to settle that case because there wasn't a large understanding about insurance broker law. And when you hear about it and certain provisions of it, it might seem hard to imagine, particularly when you have an emotional case like a wildfire case where somebody's home has in fact burned down due to no fault of their own, really, but because of a wildfire, and they've lost all their personal belongings, and they don't have enough coverage to rebuild their home. So it is an emotional situation, and then you have it coupled with this new insurance policy that's out there, as well as the insurance broker law. So in my case, the plaintiff homeowner came to my insurance broker and asked them if he would please procure a policy for them because their homeowner carrier had in fact dropped them because their home and the location where they lived was rezoned and redistricted as a wildfire zone. So like many of my cases go, my client met with them. They took an over the phone application. They reduced that to quotes that they obtained for different coverages. The plaintiffs brought with them their previous policy so that my brokers knew how much coverage they had before and they wanted the same coverage again. And my brokers procured two quotes or obtained two quotes for them. One was for $760,000, which was how much coverage they had with their previous policy. And the other was for $511,000. And that one was less coverage, but also a lower premium. And I guess I don't need to tell you which one they chose after considering both. This is expensive, right? Because this is a second policy. They have their homeowner's policy for their general policy, and now they have a special fair plan policy on top of that, two premiums, and it's pricey. So the plaintiffs freely stated throughout the litigation that they knowingly chose the lower policy coverage of only $511,000. And they thought that they had plenty of coverage and plenty of insurance. Indeed, they had two policies. And how in the world could they possibly not have enough coverage? Well, they didn't, as you can probably imagine, which is what culminated to this lawsuit. And I will show you what I'm now going to mark as Exhibit D to this presentation. This is a, just as an example, so this is a part of my mediation brief, and it is an excerpt from the Fair Plan policy. As you will see, they did select the $511,000, and there's kind of an a la carte option here, where under the Fair Plan, you just don't automatically get coverage for everything, like some folks might tend to think that you do, especially if you have just a one homeowner's policy. Here, you know, if the check mark for other structures is not checked, you don't have coverage for other structures. For personal property, if it's not checked, you don't have personal property. And if you don't like the check marks, how about over here where you see 0, 0, 0? That means no coverage for that. And unfortunately, in this case, the plaintiffs failed to appreciate that part of the policy, and they did not ask questions about what all these zeros meant. They looked at the big picture number of the 511, and they thought that that was going to be enough. And maybe it would have been, but when you have these wildfires, what ends up happening is now a whole community is burnt down, and there's only so many contractors. The price of everything really did go through the roof. Wood, labor, everything just started to cost a lot more than maybe what folks had anticipated. Certainly these plaintiffs choosing the $511,000 policy. So in any event, even though what we believe the policy was self-explanatory on its face, the plaintiffs did not think so. And they thought that my broker failed in his duty and fell below the standard of care for a reasonable broker under the same or similar circumstance, as well as my agent that I also represented, because they failed to explain the policy to them and give them proper and sufficient advice on what to procure. And I want to, again, share my screen and show you the problem that we had, and this was the problem at my mediation as well, was a lack of appreciation maybe for some of the legal authority regarding insurance brokers here in California. And indeed, it is the responsibility of the client or the insured to read his or her insurance application in addition to the policy, to make sure that we got everything right. When we heard you say, yes, you have certain types of roofing versus others, etc. One more big and important part during our mediation that was just hard for the plaintiff to believe on the other side is that while an agent may point out to their client the advantages of additional coverage, he is under no obligation to do so. And this is a case, this Jones case that we cite in many, many briefs, seems surprising to a lot of insureds, particularly ones when they're in an emotional state, such as this particular plaintiff was, having their house burnt down, and they don't want to hear about how they could have and should have asked their broker questions a year prior. So that brings me back to my mediation, and we did not settle. We had a full day mediation, but we did not use the full day. Why didn't we use the full day? This kind of parlays into my second part of this presentation, which I want to talk about, and I want to invite participation. If anybody has comments or questions or thoughts, please feel free to put them into the chat or just raise your hand, and I'm happy to call on you. But does it matter now that we have masks coming off, that we're being able to walk freely in and out of offices and outside, and it looks like maybe we're going to be moseying back into the office on a more frequent basis, into restaurants without masks, etc. Are we now going to start going back to our mediator's office? Are we now going to start going back to the courthouse for mandatory settlement conferences? And what are the advantages and disadvantages for maintaining what has now become our current norm, doing this here in these boxes, from my office, your home, our couch? I wonder, and I think that there probably will be a hybrid on the horizon, where some folks will continue to do it like this and other folks will go back into the office. But I wonder, and I think about my insurance broker case and why we didn't settle, because guess what? The case did settle. It settled about 2 or 3 weeks later over the phone, when I had a heart-to-heart with the plaintiff's counsel. And even though there was a lack of appreciation for the law and the FAIR plan, and seeing and noticing the document that I showed you with the check marks, I also had to concede and have a heart-to-heart with my client that, look, this is a really emotional case. This lady's home burned down, and she's going to be tried by a jury of her peers who might also know people whose homes burnt down. And, insurance brokers and agents maybe not be the most, sympathetic folks. Nobody really feels sorry for them, especially when their client's house burnt down. And even though the law is on their side, is the jury going to follow that law? I'd like to think that they will. Judges, when they read the law, thinks that they will. But when you got emotional ties into it, you never know. Jean and I were just talking just before we came on this presentation about a case up in New York regarding a juror who didn't follow the law and didn't follow the instruction and hid what in that Maxwell case. And so these things happen all the time is what I'm trying to say, and it's a risk. So we have these heart-to-hearts on my end, heart-to-hearts on the other end, and we settled the case. The lawyer settled the case over the phone about 2 weeks later. Now, what if we had been inside an office? What if we had been dressed up, not just from the waist up, but all the way, and had our hair done and got in our car and physically drove to the office and sat in conference rooms? Would we have stayed a little bit longer and knocked out that settlement that day of the mediation and used up our full amount of our time? I think probably. I think that it's easy when we're here at home. I'm not at my home right now, but when I am, to just click the leave button here at the bottom of our screen and pop off and say, well, you know, it is 3 o'clock. It's the last season of Ellen. I really would not mind catching this. And, you know, we can always wrap this thing up in a couple of weeks. If you're at an office and this Ellen is not an option, I think and I wonder if we would stick things out and try harder, which leads me to my next exhibit about trying harder. And it's funny because I was looking for examples of trying harder. I found this one. I just liked it. There were many photos I could have chosen, but I liked this one. You know, it's an interesting question. And I think that it's worth the discussion, because certainly that's what's going to now happen, isn't it? We're all walking freely about outside now. Just yesterday, I went to the eye doctor and I had no mask on inside, but they still had all the plexiglass up and barriers, but nobody was wearing masks. So I think we're kind of in this transition period right now, which is what makes today's conversation, you know, appropriate and ripe. What are we going to do moving forward? Are we all going to go back to our offices? Are we going to start having our mediations back in offices? Or are we going to maintain what we're doing here? I would invite any thoughts that the audience has, but I submit, I think that going back to the office is a good thing. And it would be something that I would likely do and recommend. I think it's certainly helpful when you have this opportunity to meet people from across the U.S. or wherever, even other countries, Natalie. But it's great to be able to have this opportunity and this vehicle to reach out and meet folks. But at the end of the day, do we try harder, and does it work? I don't want to say the old-fashioned way, but just the way things used to be pre-COVID. And is that how maybe eventually, slowly but surely, we will get back there? I want to talk about relationships, which brings me to my last slide for today. But relationships, and this photo I picked to express how I feel about relationships. And I could have chose a group of folks in suits sitting around a conference table. That was certainly one of my options, but I liked this one because to me, this expresses being in the trenches, working from the ground up together. And I feel that, at least in my experience, when I started working even at my firm in Murchison in 2008, you work with other folks that you figure things out, and you do the heavy lifting together, and you bond, and you go out for coffee or lunch, and you get to know folks, and you build these relationships. How are we going to do that from our living room and kitchen and talking through boxes? If there is a new hire at your place of employment, how do we get to know that person? I think that, in my view, I think that going back to the office is a good thing. I think a hybrid is probably going to be great for a lot of folks too. Likewise with mediations. I liked the mediations being on Zoom initially because I could see my claims handler that perhaps I never even would get to see, but just to talk on the phone. But is there something to be said if you have a conference or even a mediation that's a massive mediation, and they're hopping on a plane and flying across the country and staying, across the country and staying at hotels. I'm picking them up at the airport. When you have that kind of a commitment to do something, do we try harder and make it work? I don't know, but I wonder. Of course, there's the cost benefit aspect of it all as well. It's certainly more expensive to do things in person, but if it's more effective, does that matter? I just had a deposition last week where it was me, my client, the plaintiff's counsel. We had an interpreter, the court reporter, another witness there. And at the outset of the deposition, the plaintiff's attorney suggested that he didn't get a copy of the transcript from the first volume of the deposition. And he wanted a copy of that transcript right now before the deposition began. And we did not have one to offer him. And he said, well, then this deposition is over and it's not happening. Click with that leave button, poof, gone. What if we were back in the offices and this attorney had to dress up and drive down the freeway and pay $40 to park in downtown and come up the elevator and go into our conference room? Would that be an option just so easily, just so quickly? I don't think so. In addition, right now, the exhibits that I've shown during this presentation are one page. If you have many exhibits that are hundreds of pages, maybe a contract or a policy, scrolling through that on this program isn't always the easiest thing to do. And is it better to do things back in person again? Any questions or comments? Feel free. I think I see a question from Tina Jones here. Okay, so Tina says, I hope you don't mind if I read it out loud. When emotions are so high, walking or clicking the leave button are the options of the moment. I don't think we can get back to normal, maybe a new normal. Globally, COVID variants are still raging. I mean, you're right about that. And there's no question that COVID is technically not over. And maybe I'm being optimistic that we're starting to go back into the office and things are kind of getting back to normal. Maybe because I'm just looking forward to it and I want it so badly. But at the same time, I think you're right. And I do think that there's going to be hybrids. Hey, look, I have colleagues who I don't think are ever coming back to the office again. And that is where my work relationship hat comes on. And I think, well, how are we going to stay friends? And how are we going to have longevity? How are you going to be loyal to the company if you don't maintain these relationships and get to know folks? So I think that there's conversations and thoughts on both sides. I also have thoughts about trials. What are we going to do about trials moving forward? Like I said, I had a trial during the middle of COVID where people were masked up and the jury was scattered about the gallery and there was plexiglass around the witness box. Jury voir dire took 3 days as opposed to what might have just been an afternoon. I know that in Alameda County in California, at least for a period of time, I'm not sure if it's still the case, but they were mandating Zoom trials. I just was at a conference last winter where some of my colleagues were ramping and raving about Zoom trials, just thinking that they're the greatest thing. You could really focus on a juror's eyes because you can blow up these boxes and really look at their face and see what facial, expressions that they have. And so I guess from that standpoint, it is potentially a good thing. In my trial that I had, because of COVID, some of the witnesses had to appear by video conference. They were not my witnesses, thank goodness, because it was extraordinarily difficult to really truly see the witness on video conference. I suspect that if video conferencing is here to stay, that we'll get better technology down the road. But right now, and at least in my trial, the jury could barely hear what this witness was saying. It was the plaintiff's husband. They could barely see him. We had technical difficulties. And again, because they were scattered about the courtroom, they all didn't have the best vision of the screen. Is that what made her lose the case? I don't think so, but I certainly would not want one of my primary witnesses to be appearing by video where they can't make the connection that you would otherwise expect a witness to make with the jury if they were live and in person. One of the reasons I don't do PowerPoints and I just kind of go back and forth with these exhibits is I'm talking to you and I want to see you and I want you to see me. And it's hard when you're saying, look over here, and you're not looking at me. I don't see you, you don't see me. I think that these boxes are great and they're swell. But with a lot of boxes here, we have just a small image of each other. I'm curious, if there's any, opposing thoughts about any of this, but I will say, sure, it would be great to have an opportunity to have maybe a doctor who has moved and now lives in New York, and instead of flying them out, they can appear by Zoom. If everybody agrees, that's a great thing. But if that doctor is really going to make or break my entire case, I would urge the company to fly that doctor out and have them appear live if it's at all possible to do so. I see somebody's hand up here and I'm going to shake it. I don't know how to do that, but who raised their hand? Was that you, Natalie?
Yeah, that was me.
Okay.
So I think that you're exactly right. For litigated cases, for our relationships to work, we really have suffered the loss of the relationship. The water cooler time, the let's go have a coffee, let me find a mentor in the office to help guide me through politics. All of those kinds of things are lost. Tell me about this judge, tell me about this expert witness. All of those things have become much, much more difficult. The flip side of that, though, is this kind of technology. I know it's that you're in Los Angeles, and so it's maybe not such a big issue in the greater LA basin, but globally, this technology is being adopted and has been used much, much longer back than the COVID crisis leads a lot of Americans to believe. But in Europe, we've been using this kind of technology because it's better for the planet, for us to stay home and not be out and about commuting and adding our fossil fuel emissions to the air and et cetera. So we've been using it in Europe because it's the greener solution. But for our colleagues in Africa or in rural Asia and East Asia, this provides them access to justice that they didn't have before, because they can't get into a city, they can't get into a courthouse, they can't, it's just too expensive, it's too time consumptive, they don't have childcare, et cetera. And so although it might be more difficult for the advocates that are involved, the access to justice and the green aspect of this, I think will keep this kind of platform and this kind of interplay going for forever and ever, amen. I don't think that it will ever go backward.
Oh, I agree. I can't imagine, especially companies, not noticing the cost savings that are going on from that perspective alone. Let's see, can we talk, let's see, John Bracey has a question. The dynamics of a mediation with insurers participating as third parties, how can that affect the settlement process in outcomes? So a lot of times, I think you're talking about, for example, in my case, if I'm reading this correctly, but when you say insurers participating as third parties, are you suggesting that there's a, Jean, what do you think? Is there, well, I guess I don't really understand.
Well, how about if the gentleman just raises, just unmute yourself and ask your question? No?
That's fine.
Oh,
Well,
yeah,
I
I didn't really mean as a third party.
Johanna Bracey. Okay.
Yeah.
Johanna, go ahead, please.
Yeah, I didn't actually mean as a third party. I think I sort of misspoke in that sense. But when you have an insurer participating and a plaintiff and a defendant, and the insurer is also, they're weighing and, or, they're going to have to approve the settlement, for example, how does that affect the interplay between the parties?
Okay, that's a great question, because in a lot of these professional liability policies, there are consent clauses. And my broker, for example, in the insurance broker case that I was talking about earlier, he absolutely did not want me to settle that case. There's emotional aspects on the defense side as well. I did nothing wrong. Does this mean that I did fall below the standard of care if you settle, particularly if you settle for something in 6 figures? What does that say about me? And obtaining consent is it can be a struggle sometimes. What I like to do with clients that I think are going to be offended or bothered by a settlement, and there's a consent clause, is I invite them to the mediation. And sometimes recently, once, and gosh, I think it was even for this case I'm talking about, I invited my expert to come in just for a little bit and sit in at the mediation. I want my client to hear about the other side that maybe it's so hard to see now. And I want to hear about it in the mediation setting. So I'll invite them to come in to meet the mediator so they get to see the mediator. Maybe they'll meet the claims handler that they don't usually get to see and meet. And we come together as a team, if you will, in resolving a case as opposed to just me and maybe the claims handler or plaintiff's counsel at the end of the day, as was in the other case. And frankly, by the time I did settle the case with the plaintiff's counsel over the phone, as I suggested earlier, my client already had heard everything and he said, fine, go ahead, settle it, that's fine. If you have a burning limits policy where the more that we spend and the more that we litigate, the policy is depleting. A lot of my legal malpractice cases have that. Now that's another level of issues there, because my client doesn't want to settle a case because she thinks she didn't commit any legal malpractice. But the longer that we stay in this case, the less money we're going to have to settle at the end of the day. So not only do I need your consent, I need it right now. That is a difficult story to sell sometimes, especially if you have a client that really feels that they didn't do anything wrong. I definitely invite that client to the mediation and hope that between me, the mediator, and any documents that are produced, that they'll see how important it is to resolve the case sooner than later. I hope that answered your question.
You know, Lisa, one thing you said struck me just now, and I'm sure it would with the rest of the audience here. You talk about inviting your client to the mediation. Your client's a party to the case.
Well,
and
that's true.
I think, yeah, and that's one thing where these online mediations, you always have the client showing up. At the very least, they're available by phone, and you can talk to the mediator, can talk to them. I mean, now as a mediator, I think back to many mediations I went to when I was in practice. Of course, those were in person, but it was just me. And I had the client on the phone, and I had the claims examiner, you know, wherever they were located, on the phone as well for when the mediator came in. And I know that, you know, that happens, but I think that is one benefit for what we'll call Zoom, but for the online mediations, using those platforms, because of course your client is there, as the courts generally order that they attend, you know, but they don't just rely on the claims professional to be the one to come in and settle the case, and they don't have to come. And so you have the claims professional and maybe even the high up manager or the higher up more access to the decision makers, not just both the claims end of it and the client end of it are there participating in the mediation.
Sure, I hear that, and I think you're absolutely right. They should absolutely be there for every mediation. You know, I just how we used to have the claims adjuster or handler on the phone, even though really having them be a part of this on these Zoom boxes, I think, has been extraordinarily beneficial, as opposed to just being on the phone. I am grateful a lot of times when I'm at a mediation and my claims handler is there with me in another box, so they can see how things are falling apart and realize and be a part of it as it unravels, and see why we didn't settle a case one day. Whereas if they were on the phone and I'm just calling and giving them updates, it's kind of hard to understand, well, why didn't that case resolve? I don't really get it. Likewise with clients. I have clients, even though they really should be at the mediation, for whatever reason, opt not to. They just authorize their consent ahead of time and say, go, you have my consent to settle this case within the policy, and you go ahead and settle it with the claims handler. So but I appreciate it. It's always better if the client was there. For some reason, some clients opt out. I think for the plaintiff, of course, it's necessary. I don't know how you would ever be able to have a mediation with it. Although I will say, I recently had a mediation by these Zoom things, and there's another reason why I have some concerns, where the plaintiff was allegedly there, but was he? Don't think so. And you just never know with these boxes, who's standing in the corner right over there, or who is not in the room. And so there is that aspect of it as well. In depositions now is one of my admonitions. I ask everybody to shut off their electronic devices, and if they'll agree to turn over their phone, so I know that there's no texting with their lawyers in the middle of the deposition, or texting with anybody, really. So there's advantages and disadvantages to all of this, and I suspect there will be a hybrid as we move forward. I wonder what, on a scale, how it's going to tip. Is it going to be a hybrid where it weighs more with people staying at home before it starts to tip more of people going back to the office? That's what I think is going to happen. I think that people are going to miss each other. I miss people. I couldn't stand being in my kitchen every single day with my cats. And I love my cats, okay? And I know what they do all day now. I don't need to have that information forever. So I really, really am looking forward to coming back to the office and going back to the mediator office and to have the in-person depositions. I know not everybody feels that same way, but I wonder how it's going to be ultimately down the road. Any other thoughts, questions?
It's a brave new world, as an author once said, right?
Well, I will say that I do appreciate this time here today, and especially the Will Work for Food project. And in researching for today, I definitely did read up on all of the good work that's being done, and I reviewed a lot of the videos of other programmers, and I just think that this organization and what we're doing here in teaching for free is a really great thing, and I appreciate you allowing me to be a part of it. I think that, you know, bottom line at the end of the day, really, mediation is really a great way, especially in professional liability cases, to resolve cases. I wonder what the best approach is. And I don't know that there really is a right answer, but just offering up my thoughts today. I think I see somebody in the chat box. Oh, of course, absolutely, I will. And I hope everybody donates as well. And yes, I will. Thank you very, very much for hosting me and having me here today. And with that, if I don't have any other questions, I think that's all I have today.
Well, thank you so much, Lisa. I would ask everybody, keep in mind, this is the defense view. We'll have the plaintiff's view and both extremely accomplished and successful trial attorneys for their respective clients, sides of the bar there. Coming up next month, we'll have an attorney who will be talking from the plaintiff's side on the similar issues. And you get to hear what he may think about you know, all of this, John Teller. So anyway.
Oh, John. Oh, my goodness. Oh, well, I'll have to tune in to see John.
Well, there you go. You can be the advertisement for him. He's getting multi-million-dollar, you know, big 7-figure verdicts and lots of awards. So it'll be interesting to see what he thinks too on this, and mediations, and where this is all going, and how either side looks at them, you know, whether they're the online or they're the in-person. So absolutely. Anyway, yeah, thank you so much. Anybody, anything else? All right, thank you, Lisa. Have a great day. Have a wonderful day, everyone else. Good evening if it's